All right, welcome to the Chapter 1 video lecture, Criminal Law and Punishment and Overview. So this is just the first couple of chapters are general principles that are going to apply to all different aspects of the criminal law. Your textbook, the slides that kind of come with it are going to always start off with some learning objectives. If you can explain these, you will be well prepared for the exam. But the first thing we want to talk about are the core felonies. There are two types of felonies. Well, first of all, felonies are crimes that are punishable by 1 year or more in prison, and misdemeanors are punished by up to a year in prison. Anything more than a year is a felony. And we have some core felonies. So we have felonies against persons and then those against property. So the core offenses against the big ones against persons are murder, manslaughter, rape, kidnapping, and robbery. And we are going to talk about each one of these crimes in depth later in the semester. The core crimes against property are felonious theft. And this is noted because theft could also be a misdemeanor. That's why this is worded this way. Robbery, arson, and burglary. And we will again talk about each one of these later in the semester. So those are the core felonies. And all of the rest of criminal law is kind of based on police power of the states. States are free to use their authority to regulate behaviors and punish people that do not engage in those behaviors. Your book does a nice job explaining this section, and then we kind of shift into a compare and contrast for crimes and torts. Now, torts are civil cases, they are private cases, whereas a crime is prosecuted by a prosecutor because the injury is to society as a whole. This is a really nice little slide that you might see some of these principles on your test. Torts and crimes apply to everyone. They all originate from this idea that there are certain behaviors that are just unacceptable and we should not engage in. Differences are prosecutions are brought against the state by a prosecutor, whereas a tort can be brought by a private individual. Now, a great example of how some actions are distinct and some are the same action can lead to both is the O.J. Simpson case. So he was first prosecuted by the state of California and he won. They were not able to convict, prove that he did this beyond reasonable doubt. Then he was later sued by the victim, his spouse's parents, his in-laws, and he lost the case that they brought as a civil case because we had a lower standard of evidence there. If you are convicted of a crime, you will either pay a fine to the state or you will serve time in the custody of the state in a jail or prison. Whereas if you lose your tort case, you will have to pay money to the person who sued you. And a criminal conviction is supposed to be kind of this condemnation of society. And the tort is just a compensation for the harm you caused to one person or a group of people. Now, a huge difference for our purposes that we really care about are that the state has to prove each element of the crime. And most crimes are going to have at least 3 elements beyond a reasonable doubt. Whereas in a civil case, the plaintiff only has to show that this is a preponderance of the evidence. So a preponderance of the evidence is generally thought of to be 50% plus a feather. So if you can get to that 50% plus a tiny bit more, you are entitled to the relief you're asking for. Whereas proof beyond a reasonable doubt is that do has the prosecutor resolved any lingering thoughts in your mind that there might be a different person, there might be a good reason why this kind of happened. if the state has resolved all those reasonable doubts, all those questions that we as like humans just come up with about things and why this happened, then the jury should convict the defendant. All right, so another like huge thing out of this chapter is just kind of the different ways that we classify crime. So we've already talked about one classification, felonies and misdemeanors. And we're going to see that again, just reinforced here, local jail after 1 year, punishable by confinement of 1 year or more, fine, or death. Some states are capital states like Indiana, so the death penalty is a felony. Now, there is also other classifications structure. There are crimes that are mala in se. These are crimes that we deem to be inherently wrong or evil, and these often involve crimes against a person, right? Like murdering somebody is inherently wrong. We expect that every member of our society understands that this is inherently wrong behavior. Rape and like serious assaults, we also expect you to understand you should not be hurting people or forcing other people to have sex with you. These crimes are inherently wrong. They violate another person. They violate the standards of society. So those are crimes that are mala in se. Crimes that are mala prohibita are behaviors that are criminal only because we have a statute or an ordinance that says they are criminal. A statute is a state level law and an ordinance is a local or county level law, depending on the state you're living in. So an example of something that's mala prohibita is a minor who consumes alcohol. There's nothing inherently evil about consuming alcohol, and there's not a magic age when it becomes acceptable, except for the fact that we have a statute that says you cannot drink alcohol until you're 21. If you drink alcohol at 20, that doesn't mean that you're inherently evil. So that's an example of a mala prohibita offense. And even some things like embezzlement maybe is not inherently evil, but we have a statute that says it's wrong to take property that is not yours and convert it to your own personal use. So even some of the more serious offenses could be classified as mala prohibita depending on your perspective. All right, let's see. Now we're going to talk about something that's super important that I really hope students in the past have struggled with this concept. So I really hope that you guys do not. And if you're not clear, this is a great time to email me. The sources of criminal law. What I really, really, really want you to remember from this is that almost all criminal law is in the state criminal code. It is almost all in the state criminal code. Criminal law is state behavior. The state is the one that regulates almost all homicides, almost all robberies, almost all crimes occur at the state level. Okay. There is the Model Penal Code, and we will be working through the Model Penal Code this semester. This was written in the 60s and 70s by a group of lawyers and scholars to try and reduce the discrepancies in the criminal code between states. Most states have adopted big pieces of this, so it is found throughout the country in criminal law. No state has completely adopted it 100%, but most states have multiple elements of it. There are also municipal ordinances. So both states and Muncie has its own ordinances about certain things that as a source of criminal law. And a lot of the day-to-day cases, like disorderly conducts and things, are charged under municipal ordinances. Now, the federal government has its own criminal code, the United States Criminal Code. This is where they prosecute those things that are federal crimes, like mail fraud, crimes that cross state lines, like drug trafficking. Again, though, most of what we think of as criminal law, most of what you see on TV is going to be in that state criminal code, okay? Administrative agency crimes. So these are things like the IRS could initiate a prosecution against you for tax evasion or other tax crimes, so something like that. And then there's informal discretionary lawmaking, which occurs, again, more informally in the judgment of individual actors themselves. So when we look at the United States, we have 52 criminal codes in our country. Each state has one. Washington, D.C. has one, and there's the federal criminal code as well. Those who can make these laws, those with the authority to do so, are the states. Again, they have broad authority to regulate human conduct and human behavior as part of their police powers. And this is where most criminal law is. The federal government has a more limited ability to criminalize conduct and behavior. The book notes here, and this is an important reminder as we work this semester, that we are in a situation where we have mass incarcerated people. We have the highest imprisonment rate in the world, and in this class it's a kind of good thing to think about why and should some of those maliprohibitive crimes be crimes where we do more restorative justice approach, or where we do other things to remedy the harm than incarceration. So we're going to jump ahead to some other things that we want to talk about, which are criminal punishment and theories of punishment. So punishment itself is intentionally inflicting pain or other unpleasant consequence on a person. We've all been punished at some point or another just by our parents or guardians, grandparents. But criminal punishment has 4 specific criteria. So this is a definition of criminal punishment. Go ahead and highlight that. Criminal punishment inflicts pain or other unpleasant consequences. They prescribe a punishment in the same law that defines the crime. So we cannot borrow from another part. It has to come from the same spot. Is intentionally administered, and it is administered by the state. So criminal punishment cannot be accidental. It must be purposeful, and it has to come from the state or federal government or the county government, but it has to come from a government authority. So that's the definition of criminal punishment. Now, theories of crime. Retribution. This is the idea that we're going to inflict the pain and punishment on an offender so that they can pay back their crime. So an eye for an eye idea here. Whereas prevention is sometimes that, or rehabilitation perspectives look at punishment as a means towards a greater good, and if we punish this way, the idea is that we can reduce or prevent future crime. So this is more of a crime prevention goal, whereas this is more of an eye for an eye. You did the harm, so you did the crime, so you should do the time kind of thing. Each one of these has criticisms. Every theory or theoretical perspective always has a critique. Retribution is difficult to translate abstract justice into concrete penalties. Meaning, if you think about this, like we don't kidnap a kidnapper, we don't rob a robber. So we have to translate that harm to a different medium and then impose that punishment on the offender. Retaliation is not supposed to be a part of civilized society, so we should not have like vigilante justice, and the goal should not just be to retaliate, the goal should be to correct. This undermines free will, and multiple crimes do not require any type of culpability to qualify for punishments. We have a lot of strict liability offenses or things like that that do not require a specific bad intent on the actor. Prevention, there's multiple theories. The first one is general deterrence. This comes from Jeremy Bentham in the 1800s. We're looking at making the offender an example to society, and that will deter others. Again, all of these have critiques. There's this idea that we don't always engage in this rational free will. So inflicting punishment this way is not maybe logical. It punishes just for the sake of punishment. Threats of punishment are not going to equally impact all crimes or individuals who are willing to commit a crime. And human behavior is unpredictable. Think about this, like a lot of crimes occur when somebody's under the influence of drugs or alcohol. So maybe they're not engaging in this type of rational choice-based argument. So punishment is not maybe going to work the same way. Incapacitation is that we're going to commit future crime by making it physically impossible for the offender to harm. So the three types of incapacitation are incarcerating someone. This is the most common. Altering surgically or chemically to make them incapable. This is going to largely be unconstitutional. We do not, we cannot engage in this behavior. It's cruel and unusual to surgically alter or chemically alter an individual. And then executing somebody. This is, about half of the states have capital punishment, so this is only an option in about half the states in the federal government. But in those states, this is. In those non-capital states, the most harsh punishment is life in prison without the possibility of parole. Criticisms of this. Incarceration just moves someone from outside society to a jail or prison, and it doesn't maybe change the behavior, so maybe they just commit crimes in jail or prison. And incarceration is generally temporary. Most people are not sentenced to life in prison or an execution, so most people are getting back out, and maybe we did not address the underlying behavior. Rehabilitation. This is the idea that forces beyond an offender's control cause them to commit crimes, and that the person is not making these choices and are not blameworthy, and we should treat these offenders to change the behavior. This is hard. Causes of crime are extremely complex. If you think about back to your 102 class, you spent an entire semester learning about multiple theories of why people commit crime. There wasn't just one. So basing the criminal law on just this idea alone is problematic. Human behavior is not a hard and fixed thing. It changes. So a lot going on there. If you find this part of the class interesting, there is a lot of empirical evaluation of these different theories that explain human behavior. So that's kind of an introduction. I would recommend that you focus a lot on the definitional concepts and understand those classification schemes. The next part of the chapter explains the text case method and how to find and read a case. There may be questions on this on your exams, so I want you to know, and also this will help with those case brief assignments coming down this semester. So the text case method is that the book contains both definitions and cases as examples. All the excerpts are edited appellate decisions, not trial transcripts. And there are no excerpts from a case where the defendant was acquitted. So these are all defendants who were convicted, and we have a legal issue based on criminal law to resolve. But it provides great examples. Now, some terms. We have trial court. So this is the court that actually hears the evidence and makes it the initial decision. The decision can come from the judge or the jury, but this is the case where all the evidence comes in and somebody evaluates it. The evaluator can issue a not guilty verdict. This means the state did not prove all the elements of the crime. not necessarily the person's innocent. They can acquit the defendant, which means that they find the defendant is free to go, not going to be held responsible for the wrongdoing, or they can convict the defendant. This means the person has been found guilty and the prosecutor met their standard. This is going to be the most common outcome in criminal cases. Now, each of these cases that you're going to see in your book have the title, the citation. They have a procedural history. This is important. It lets you know what the person was convicted of. They're going to have the name of the judge, the facts, and they're going to have the judgment and the decision, so the outcome and the reason why. So again, this is kind of reinforcing different parts of the case brief. The opinion is again going to be the reasons. The holding is the rule, the outcome. This person needs to have a new trial because blank. Some of these cases are going to have more than one opinion. So majority opinion is the rule, the outcome. There's a concurring opinion, which means the judge agrees with the outcome but has a different legal basis to explain their position. Plurality opinion means that there was not a consensus on the rule of law, but they all agree that this is the right outcome. You can also dissent, which means you disagree with the outcome. Then your book has sections on briefing cases and finding cases. Again, some of these things could show up in your exam, so I encourage you to read them. And then your book in chapter 1 has Bond versus United States, which is an example of the text case method. In this, the legal question is, was arsenic a chemical weapon under the United States Criminal Code? And we have a defendant who is, I think, a biologist who understands chemicals, and her husband and best friend had an affair together. Her best friend got pregnant with her husband's baby. They're divorcing, and she leaves chemicals on like the doorknob, and the girlfriend gets a rash. She also left it on the mailbox because she was convicted and sentenced to 6 years for leaving these chemicals behind. And I think she did it 24 different times, and most of the times it was unsuccessful, but one time a chemical burn resulted. And so the question is arsenic a chemical weapon as defined under the United States Criminal Code, which requires which is explained that it forbids any person to knowingly develop, produce, otherwise acquire, transfer, directly or indirectly stockpile, retain, own, possess, use, threaten to use any chemical weapon. And chemical weapons are toxic chemicals and their precursors, except were intended for a purpose not prohibited under this chapter. So she did do this, and the question is, why? And we see, if you read to the end, you see that the judgment of the Court of Appeals is reversed and they remand it. So they send it back for more cases. So this is an interesting case to get started with this semester. I hope that you look through it and enjoy it. All right, that's it for this video lecture. I will see you next week.